Sometimes, life throws you curveballs from the most unexpected places. You know, you work hard, you save up, and you finally get that perfect little slice of heaven, that house with the white-picket fence. Or maybe just a good, solid fence. It's supposed to be your sanctuary, a place where you feel safe, where your kids can play, where you can just be. You dream of quiet evenings, barbecues in the backyard, maybe a little gardening. And then something small, something seemingly insignificant, comes along and turns your world upside down. It's often not a big dramatic event. It's not some grand conspiracy. More often than not, it's something far more mundane. Something that feels almost ridiculous to complain about, but it eats at you day by day until it becomes this enormous, crushing weight. Something like a fence. I remember hearing about a young couple. Let's call them John and Sarah. They were just starting out, full of hope, you know. They found this charming little house in a quiet, tree-lined neighborhood. It had a decent yard, perfect for their 2 young kids. The kind of place where neighbors waved and kids rode bikes freely. Everything felt right. But there was an old fence running right down the middle of their property line with their next-door neighbor. It wasn't exactly a grand structure, more like a collection of weathered planks and leaning posts. It was old, a bit flimsy, and frankly, a bit of an eyesore. For John and Sarah, with their little ones running around, it also felt like a safety hazard. They pictured their kids trying to climb it, or worse, pushing through a loose board. So, being good neighbors, they thought, okay, let's approach Mr. Henderson. Mr. Henderson was the man next door. A bit older, lived there for decades. They figured it was a common courtesy, a reasonable thing to do. They planned to suggest going in on it together, splitting the cost of a new sturdy fence. It seemed like the most logical, most neighborly thing to do. They just wanted to make their home, their shared space, a little better, a little safer. They had no idea that this simple, good-intentioned idea would be the spark that ignited a years-long legal battle, transforming a friendly neighborhood into a battleground over a few feet of property. So, John and Sarah, with their hearts in the right place, knocked on Mr. Henderson's door. They explained their idea, how a new fence would benefit both properties, improve safety, and even boost property values. They suggested getting a few quotes, picking something nice, and splitting the cost right down the middle. What they expected was a nod, maybe a little discussion, perhaps even a handshake. What they got was a cold, flat-out refusal. Mr. Henderson, with a stern look, told them that the fence wasn't his problem. He claimed it was entirely on their side of the property line, therefore entirely their responsibility. He even went as far as to say that if they so much as touched his fence, he'd sue them for trespassing and property damage. The whole conversation took a sharp, unexpected turn. John and Sarah were bewildered. They had tried to be reasonable, to be neighborly, and now they were facing hostility and threats. Naturally, this caught them off guard. They figured, well, maybe he's right. Maybe it is entirely on our side. So they decided to do their homework. This is where things start to get a bit more legal. They pulled out their property survey, which is essentially a detailed map of your land, showing exact boundaries. If you don't have one, you can usually get a copy from your county's recorder's office or assessor's office. And lo and behold, the survey clearly showed that the old, rickety fence was indeed a boundary fence, meaning it sat right on the property line, straddling both their land and Mr. Henderson's. Now, in many states across the U.S., including, let's say, California, where this story is set. There are specific laws regarding boundary fences. For instance, California Civil Code Section 841 generally states that adjoining landowners are presumed equally to benefit from a boundary fence and are equally bound to maintain it. This means that unless there's a specific agreement otherwise or a unique circumstance, both neighbors share the responsibility for maintaining a fence that sits on their shared property line. This includes the cost of repair or replacement. Armed with this information, John and Sarah tried again. They drafted a polite but firm letter to Mr. Henderson, explaining what they'd found in the survey and citing the relevant California Civil Code section. They reiterated their willingness to share costs and offered to show him the survey. They even included a few quotes from fencing companies. They thought that presenting the law clearly and calmly would make him see reason. It didn't. Instead, Mr. Henderson became even more agitated. The small acts of unfriendliness started to escalate. He'd loudly complain about their kids playing in the yard, claiming they were too noisy. He once deliberately pruned a tree on his side, letting the branches fall squarely into John and Sarah's yard, leaving them to clean up the mess. He even called the police on a couple of occasions for trivial things, like John mowing the lawn too early on a Saturday, which, by local ordinance, was perfectly within the allowed hours. It was a clear pattern of harassment, designed to make them uncomfortable and force them to back down. Despite the growing tension, John and Sarah decided they couldn't live with the dilapidated fence any longer. They had given Mr. Henderson ample opportunity to cooperate, and the law seemed to be on their side regarding shared responsibility. So, they moved forward. They hired a reputable fencing company, made sure they got a detailed invoice, and meticulously documented every step of the process with photos and videos, before, during, and after the fence construction. This kind of documentation is absolutely critical in any legal dispute, as you'll see. Once the beautiful new fence was up, making both properties look much better and feel much safer, John and Sarah sent Mr. Henderson a formal invoice for half the cost, along with copies of all the documentation. They gave him a reasonable time frame to pay. His response, not a check, but a summons. Mr. Henderson had made good on his threat. He filed a civil lawsuit against John and Sarah, alleging trespass and nuisance. And that, my friends, is when a simple fence problem became a full-blown legal battle. So there they were, John and Sarah, staring at a legal summons, accused of trespass and nuisance, simply for building a fence on their own property line. This is where understanding the law, even just the basics, becomes incredibly important. Let's break down what Mr. Henderson's lawsuit meant and how the legal system would likely view it in a state like California. First, let's talk about civil lawsuits. Unlike criminal cases, which involve the government prosecuting someone for breaking a law, civil lawsuits are usually disputes between private parties, individuals, companies, or organizations. The goal in a civil case isn't to send someone to jail, but typically to resolve a dispute, often by awarding damages, money, to the injured party, or by ordering someone to do or stop doing something. Mr. Henderson's first claim was trespass. In legal terms, trespass to land generally means intentionally entering or remaining on someone else's property without permission, or causing something to enter that property. Now, on the surface, it might sound like building a fence on the property line could be considered trespass if a portion of it extends even an inch onto the neighbor's side, or if the workers had to step onto his land during construction. However, remember that critical detail. The fence was a boundary fence, meaning it sat directly on the property line. As I mentioned before, California Civil Code Section 841 is key here. It essentially says that a fence on a common boundary line is presumed to benefit both property owners equally, and both owners are equally responsible for its maintenance. This presumption means that if one neighbor wants to repair or replace the fence, and they've given proper notice, they generally have a right to do so, and the other neighbor is expected to contribute their fair share. For John and Sarah to be found guilty of trespass, Mr. Henderson would have to prove that they acted outside of these rights, perhaps by deliberately encroaching on his land beyond the boundary line, or by causing damage that wasn't a necessary part of the construction. Given they had a survey and tried to involve him, it's a tough argument for him to win. Then there's the claim of nuisance. In California, a private nuisance generally refers to something that interferes with a person's use and enjoyment of their property. This could be anything from excessive noise, foul odors, or even something visually offensive that significantly impacts a neighbor's ability to use and enjoy their land. Mr. Henderson might have argued that the construction itself was a nuisance due to noise or disruption, or perhaps that the new fence, in some way, interfered with his property. However, for a nuisance claim to succeed, the interference usually has to be substantial, unreasonable, and continuous. Temporary noise from a construction project, especially one that improves the shared boundary and was done after proper notice, typically doesn't meet the high bar for a legal nuisance. The law recognizes that some level of inconvenience is part of living in a community. So, how does a civil case like this proceed? After Mr. Henderson filed his complaint, John and Sarah would have had to file an answer to the court, responding to each of his allegations. From there, the case would likely enter the discovery phase. This is where both sides gather information, exchanging documents, conducting depositions, sworn out-of-court testimonies, and potentially hiring expert witnesses. John and Sarah's meticulous records, the property survey, their letters to Mr. Henderson, the fencing quotes, the invoices, and especially all those photos and videos of the old fence, the construction, and the new fence, would be absolutely invaluable as evidence. After discovery, the court often encourages, or even mandates, mediation. This is a process where a neutral third party, a mediator, helps the disputing parties try to reach a mutually agreeable settlement outside of court. It's often a good option because it can save a lot of time, stress, and legal fees. If mediation fails, the case would then head towards a trial, where a judge, or sometimes a jury, would hear all the evidence and arguments from both sides and make a final ruling. In a situation like this, the judge would primarily consider a few things. Was the fence indeed on the boundary line? Did John and Sarah provide proper notice to Mr. Henderson of their intent to repair or replace the fence? Did they act reasonably in seeking his contribution? And did their actions truly constitute trespass or an unreasonable nuisance? Based on the law and their documentation, it looked like John and Sarah had a strong defense. Now, when you look at a situation like this, it's easy to pick a side. Most of us would probably side with John and Sarah, the young couple trying to do the right thing, trying to improve their home. But it's important to consider all angles, because the law and life are rarely black and white. Let's try to see it from Mr. Henderson's perspective. Imagine you've lived in a house for decades. You've seen neighbors come and go. You're set in your ways. Then these new young people move in, full of energy and new ideas. Maybe Mr. Henderson felt like they were encroaching on his peace and quiet. Maybe he genuinely believed the fence was entirely theirs, or that he had some unwritten agreement with the previous owners that absolved him of any responsibility. He might have felt disrespected that they even suggested he pay for something he perceived as their problem, or that they moved forward with construction after he'd clearly voiced his opposition. It's possible he simply didn't have the disposable income to contribute to a new fence and was too proud to admit it. Or perhaps he was just a cantankerous old man who enjoyed a good fight. We don't know his full story, but his actions stemmed from his perception of the situation, however misguided it might have been legally. Then there's John and Sarah's perspective. They felt threatened and bullied. They were trying to be good neighbors, trying to make their home safer and more pleasant, and they followed what they believed was the legal and ethical path. They did their research, they sent formal letters, and they documented everything. From their view, Mr. Henderson was being unreasonable, hostile, and ultimately forcing them into a legal battle over something that should have been a simple, neighborly agreement. They were likely feeling the stress of a lawsuit, the financial burden of legal fees, and the emotional toll of living next to someone who had declared war over a fence. When it comes to the legal process itself, it's designed to be impartial. The judge isn't there to pick a favorite neighbor. Their job is to apply the law to the facts presented. This is why evidence is so crucial. John and Sarah's detailed records, the property survey, the letters, the quotes, the invoices, and especially all those photos and videos, would be their strongest allies in court. They would prove they acted reasonably, responsibly, and in accordance with the law. Mr. Henderson, on the other hand, would have to present compelling evidence to support his claims of trespass and nuisance, which, based on the nature of boundary fences and temporary construction, would be an uphill battle for him. One might argue that the legal process is slow and expensive, and they'd be right. Going to court, even for a civil matter like this, can drag on for months, sometimes years. It involves legal fees, court costs, and a significant amount of stress. It can also permanently sour what might have once been a tolerable neighborly relationship. This is precisely why the court system often encourages, or even requires, alternative dispute resolution methods like mediation or arbitration before a full trial. Mediation is a process where a neutral third party, a mediator, helps the disputing parties communicate and find a mutually acceptable solution. The mediator doesn't make a decision. They just facilitate. In this fence dispute, a mediator might have helped Mr. Henderson understand his legal obligations under California Civil Code 841, or helped John and Sarah understand some of Mr. Henderson's underlying concerns. Perhaps even finding a compromise on the style of the fence or the timing of construction. Arbitration, on the other hand, is more like a mini-trial, where a neutral third party, the arbitrator, hears evidence from both sides and then makes a binding decision. Both mediation and arbitration are usually faster and less expensive than a full court trial. In the hypothetical outcome of this case, if it went to trial, it's highly probable that the court would side with John and Sarah. Given the California Civil Code regarding boundary fences and their diligent efforts to comply with the law and communicate, it's likely Mr. Henderson's claims of trespass and nuisance would be dismissed, and he would be ordered to pay his share of the fence's cost. This outcome wouldn't be because the judge liked John and Sarah more, but because the law, based on the evidence, supported their actions. It demonstrates that sometimes the law does work to bring about a reasonable and equitable resolution, even in disputes that seem petty on the surface. So, what's the takeaway from John and Sarah's fence saga? It's a powerful reminder that even the smallest neighborly disagreement can escalate into a full-blown legal battle if not handled carefully. But more importantly, it highlights how the law, while sometimes frustratingly slow, is there to provide a framework for resolving these disputes. The biggest lesson here is that communication is absolutely critical, but it has to be the right kind of communication. Always try to talk to your neighbor first, openly and respectfully. Sometimes, a simple misunderstanding or a neighbor's financial concerns can be resolved with a face-to-face chat. However, if that doesn't work, and especially when significant money or property rights are involved, you need to shift to formal, documented communication. John and Sarah did this by sending letters, citing the law, and providing quotes. This proved their good faith and their attempts to resolve the issue amicably before resorting to legal action. Another vital lesson is to know your rights and responsibilities under the law. Don't just assume. If you're dealing with a shared fence, a boundary line issue, or any property dispute, take the time to look up your local and state laws. For instance, in a situation like this, knowing about California Civil Code Section 841 and how it pertains to boundary fences is incredibly empowering. You can often find this information on your county's website or by visiting your local recorder's or assessor's office. Understanding these statutes can prevent you from making costly mistakes or being taken advantage of. Perhaps the most crucial piece of advice is to document everything. I can't stress this enough. Every conversation, every phone call, every email, every letter, every quote, every invoice, every picture, every video. If it relates to the dispute, save it, date it, organize it. In a legal dispute, your word against your neighbors often won't be enough. Concrete evidence is what sways a judge. John and Sarah's meticulous records were their shield and their sword in court. Without them, their case would have been much harder to prove. Finally, don't be afraid to seek legal advice early on. You don't have to hire a lawyer for a full-blown lawsuit right away. But a consultation with an attorney specializing in real estate or property law can give you immense clarity. They can explain your options, tell you what to expect, and often help you draft those formal letters that carry legal weight. Sometimes, a well-worded letter from a lawyer's office is enough to make an unreasonable neighbor reconsider. And if things do escalate to court, exploring mediation is almost always a good idea. It's often quicker, less expensive, and can help preserve some semblance of a neighborly relationship, even if it's just a respectful distance. The story of John and Sarah and their fence isn't just about a property dispute. It's about the complexities of living side by side, about setting boundaries, and about the role of the law in maintaining peace and order in our communities. A good fence might make good neighbors, but when that boundary becomes a battleground, it's often the law that helps us find our way back to peace. What do you think about this case? Have you ever had a similar experience with a neighbor, and if so, how did you handle it?